Yes, guys. So, yesterday we have discussed section 43 small a that talk about unauthorized access, that when any person without the permission of the person or uh, other person in charge of the computer system or computer network access or secure access to such computer system, computer network, or computer resource shall be liable to pay damages by way of compensation to the person so affected. Then clause B, that if any person without permission of the owner or any other person who is in charge of computer system, or computer network downloads, copies, extract any data, uh, computer database, or the information from such computer system, or computer network, including information or data held or stored in any removable storage medium, he shall be liable to pay damages by way of compensation to the person so affected. These two clauses we have discussed, and earlier also I have told that the two line that is provided before starting of these clauses and the last line, we have to read those two lines, then the clause, and then one line, so that each wrong you can understand better. Okay, the case on these two clauses we have discussed was Vinod Kosis versus Madhvika Joshi. Here is this second case, and in this case, the name of this case is Amit Dilip Patwardhan versus Rude India Chains Private Limited. Okay, the facts of this case are that there was a Mr. Amit Dilip Patwardhan, and who was the employee of the Rude India Chain Private Limited, this particular respondent in this particular case. And the allegation of the Rude India Chain Private Limited was that Mr. Amit Dilip Patwardhan was getting, their confidential information, secrets, and have to send to the other company, the rival company, Heco Chains. And then the finally he resigned from the job of the Root India Chain Private Limited, and have joined that rivalry Heco Chains private company. Then during that, uh, you know this particular proceeding, the Root India Private Limited, they have produced the bank detail of the Mr. Amit Dilip Patwardhan to prove their case. And those bank details were not, you know the things that actually we procure in the normal case, like the police by giving the notice to the bank and getting the the bank statement from the about the any customer of the bank. It was through the hacking. Okay, and so Mr. Amit Dalip Patwardhan, he filed you know the before the adjudicating officer the claim for the compensation, that this company Rude India Private Limited has unauthorizedly accessed the the details of Mr. Amit Dilip Patwardhan, the bank details provided or stored in the his particular bank in which he has the account. And so this case became a two-sided, you can say the cross case. Here particularly the adjudicating officer analyzing that whether getting the bank details by hacking would constitute the civil wrong under section 43b, because section 43b talking about download or copies or extract any data. And Amit Dilip Patwardhan says that this data is his own data, the data of Mr. Amit Dilip Patwardhan. And so they have, or the Root India Private Limited have actually committed the wrong under the section 43 small b. Now see this case, I have shared the screen. You can also, get access. This is the original copy I got on the internet. You can also got this type of the, and here in the order, before that there is this name of the parties, and then there is this order. The first para of this order, I will share also this judgment to your class, okay? So in the first para is about the facts of this case, where the adjudicating officer is saying that the petitioner in this person, Mr. Amit Dilip Patwardhan, was the employee of this Rude India Chains Private Limited company from 2008 to 2012. Later, he left the company to join the rival company, Hecco Chains. The respondent, Rude India, claimed that that means the Amit Dilip Patwardhan, took away the company secret and was getting the gratifications, rishwat, from the Hecco Chains to lure away their customer, even with while he was employed by them. They have filed a suit to claim damages for their this theft for the trade secret. Now the complaint had come to this forum saying that his bank statement was filed as the evidence by the root chains in the court case, and it was obtained by the hacking in the bank system. Hence, Mr. Amit Dilip Patwardhan is asking for the relief under the IT Act. Okay, these are the facts. So, guys, the facts are clear to you or not?
सर एक बार थोड़ा ब्रीफ में बता दीजिए सर क्या है.
Simple. There is Mr. Amit Dilip Patwardhan, Mr. A. You can say Amit Dilip Patwardhan, Mr. A. He was working in a company. Okay, the Rude, the name of the company, the Rude India. You can say the Rude Chain India Private Limited. And the allegation of this company was that this Mr. A, who was the employee of this company, during his employment, he has to transfer the secrets, the trade secrets, or the custom. Basically, he the allegation was that he given the customer details, this type of the information, to the rivalry company, and so they filed the case just to support their case that he was doing this because he was getting the gratification from the rivalry company, Hecco Chains. They have produced a bank statement of Mr. Amit Dilip Patwardhan in which some amount was credited at the regular interval. कि ये पैसा कहाँ से आया, ये आप वहां से लेते थे. Okay, when Amit Dilip Patwardhan come to know that that means the Rude India actually got all these bank details, not going to the bank and requesting for the bank detail of this, rather through the hacking. Okay, and so he made the complaint under the section 46 adjudicating officer that the Rude India Limited, this private limited, actually committed the wrong under section 43 small b, and I have suffered the losses, so please pay me damages by way of compensation. Have you got the facts now?
Yes sir, I got it, but did the bank is also implicated? Because actually जो complication create की गई है वो बैंक की साइड से की गई है ना. They have disclosed
No.
their personal information to the this
See,
company.
yes, whatever I told you or whatever the written in the para 1, that is the concrete. Later on in the paras you will find the bank also. Bank is not denying. Bank is not denying that they have not provided. They are saying we have not provided. So that is, conclusive. They have not provided. The bank in which Mr. Amit Dalip Patwardhan has the, this account, they have given the statement that they have not provided any bank detail to Root Chain India Limited with respect to this particular customer. And so the only questions or only possibility that they got through the hacking. The second thing, that the manner, the form in which bank usually give, the format in which bank gives the bank statement, that was also not in this particular, that also indicating that it was through any other unauthorized means. Yes, now tell me.
Sir, I got that fact. Fact समझ में आ गया क्या है.
Hmm. Now you decide that whether wrong under section 43 small b has been done or not. Read section 43 again and then you tell me. Yes, Mr. Ravi Prakash Pandey, what's your opinion? Hmm? Kumar Nitesh, Sanjay.
Sir, Amit will be liable and it will fall under 43B.
Good attempt. Rohit. Yes. See, there is no ambiguity with respect to the liability, or you can say with respect to the whether the wrong was committed or not, because the facts are clear. In the para number 2 that you can see from the screen that I have shared, he adjudicating officer is saying that I have on the record a statement by the manager of the Napuda, the Thane branch, Bank of Baroda, filed before the police, that the content of bank statement match with the complainant bank account, but the format is not the standard format in which bank gives the printout. Also, the bank policy is not to give a detailed bank statement to anybody without the approval of the customer. Hence, the bank has no knowledge about how Root India obtained that bank statement of their ex-employees Amit Patwardhan. So this is clear fact that the bank has not provided, and then there is only possibility that they got through any other means by getting the access into the computer system of the bank and then downloading that information. Okay, and so uh, it's the thing we can say that the wrong of section 43 b has been completed. Then the question is about the compensation. And on the compensation, earlier also in that case, we have read that what the Delhi High Court have decided in the Vinod Kaushik versus Madhvika Joshi, that the for the compensation, it's not that if the wrong has been committed, then one has to show even the damages also, the damages that one has suffered. And if that damages are not there, then the compensation would not arise. The damages has to be proved with the evidences that this is the damages I have suffered. Okay, sometime like when the rights is violated, like in the uh, Bhim Singh versus state of Jammu and Kashmir, we read under the law of the tort that even without the damages also, the compensation can be provided. That is, that power also have with the court, I'm not denying, but it's not always. It's only when just to the you can say exemplary damage to creating the example court want to do. Otherwise, generally the compensation would be as the damages or loss the aggrieved party have suffered. Here, the adjudicating officer has saying that yes, there is no doubt about the the commission of the wrong. In the para number 3, you can say that the complainant say that the respondent has no authority to get his bank statement and have committed the offense. And then uh, in the para number 4, it is fact that Root has somehow obtained this statement filed in the evidence on the civil suit during the hearing before me, as well as in the paper they have submitted. They have not explained how they got have this statement. Neither they have no explanation, nor the bank have approved that they have given. So only possibility that they got through the hacking. And because this record was not in the physical form, so IT Act will be attracted. If they got the copy of the any document in the documentary form, then the IPC some provision of the may be applicable. But in this case, the IT Act will be applicable, and the adjudicating officer held that the section 43B has been completed. Okay. Then on the compensation, if you see section 47, because later when we will do the procedure, then also we have to discuss section 47 of the IT Act, talking about that the factor to be taken into account by adjudicating the officer, and say here on the quantum of the compensation. See, in the criminal trial also, uh, you know and in any type of the damages, when you're talking about the first, one has to establish that, like in the section 43, that whether the wrong has been committed or not. The second proceeding will be on the quantum. In the criminal cases also, the first is trial will conclude whether the offense was committed or not committed, that means acquittal or the conviction. If the court say the conviction, then on the next date, or you can say separate hearing, will be given on the quantum of the punishment. Because in the IPC you will find that the punishment up to 5 year, punishment up to 10 year. It's not that in every case the court will provide or court will award the 10-year punishment. It's the discretion of the court that has to be decided very judicially, and judiciously. And so in the quantum of the punishment, many factors of the accused also seen, that whether he is the only bread earner, very old age woman, so many things have taken into consideration to see, decide the quantum of the punishment. Similarly, here in the civil cases, when the compensation is awarded, it's not that that without any policy the adjudicating officer is given the blank head, that much of the discretionary power. And so some policy framework has been there under section 47. The three important factors has to be taken into consideration. One is the amount of gain of unfair advantage, but by whatever means made as a result of the default. Any advantage you have get, maybe sometime you have not get any advantage. Then the second thing may be the amount of loss caused. So the amount of loss caused also have to be taken into the consideration. And third, in the repetitive nature of the default. Here, what loss, the monetary loss this person have got, definitely this is the breach of the privacy and the privacy rights. The manner in which the Bank of Baroda was saying, they have not saying that we will make the inquiry how this information got into the hand of Rude India. They are very like the casual कि भाई हमें हमने तो नहीं दी जहां से गई गई. Okay. And this adjudication officer was also very surprised that is this the manner of having this much of the sensitive personal data, sensitive personal information by the bank official. But he also observed that what loss the petitioner have actually suffered. He have not suffered any monetary loss. He have not suffered any monetary loss, because those statements have not been used for any type of the extortion or other purposes. Those statement was only put in the court or here. And so it's not that he has suffered any type of the monetary loss. The second thing, that even if he has not suffered the monetary loss, and the forum thinks that there should be punishment compensation, then also can be given. But here the adjudicating officer has observed that Mr. Amit Dilip Patwardhan was also not come up with the clean hand. These are the certain facts that showing that he was transferring the customer's confidential of the company in which he was working. And so he was also not with the clean hand. And so the wrong was, court said that yes, wrong said, but on the compensation, court have not awarded any compensation. And then court even raised serious concern about the way the investigation done by the police authorities, the way the prosecutions and the other things has been done. And so with that, the court decided without cost, without any compensation. Now, with this case, we have learned three things. The first thing is that about the section 43b, that is about the data. The second thing is about the compensation, that it's not the only when someone say that section 43a is wrong is committed, or the wrong of section 43b, or any wrong of under section 43 is committed, that means there would always be the compensation. For the compensation also, it has to be proved, like proved in the civil court, by adducing the separate evidence that, sir, this is the damage, monetary damage I have suffered. Okay, and that have to be proved separately. Okay, like it was observed by Delhi High Court in Vinod Kaushik case also. Okay, and here also. The second thing, that in case of the awarding the damage or the quantum of the punishment, the certain things has to be taken into the consideration. One is the section 47. The other thing, like I have taken that, even the petitioner was not with the clean hand, and so that may be the one consideration for not awarding the compensation. Okay, now there are two three important paras that uh, I would like to read and discuss with you. This is the para number 5, and here uh, you know uh, A, the first para, the bank manager of Bank of Baroda has completely denied any role of the bank in giving the bank statement of their customer to third party, but the bank has done absolutely no investigation on its own to find out that how this occurred. This speaks volume about the apathy of the bank regarding the privacy of the customer's sensitive data. However, as they are not a party to this case, so I am not passing no further order regarding the liability of the bank. The respondent have violated the privacy of the complainant and accessed his personal sensitive data through the dubious means. They have no right to bank details of their ex-employees. If they had any suspicion about the bribes and being paid, they should have voiced these to the police and let them to do the investigations. Any private investigation by various dubious means which violate individual privacy and personal sensitive data need to be viewed seriously. In present case, the bank statement has not come from the physical record kept with the bank, but definitely from the electronic record with the bank. Hence, the IT Act definitely come into play. I hold both the respondent guilty of violating Section 43B of IT Act read with Section 66, and at the same time the complainant has not come to this forum with the clean hand and perusal of entire record before me prima facie show that he was disloyal to employer while they were appreciating his work, giving him promotion. He colluded with the rival company, got hefty amount in his bank account for them, and diverted his employer customer to the rival. Later on, he joined the rival company. The forum cannot condone such behavior. However, a separate court case is on between the various party, and I would not like to comment further. Okay, and then in the para number D, the adjudicating officer also raising concern about the investigation by the police, etc. So you can read yourself with this case. I will upload on the class, there you can read it clearly. Okay, so does this case is clear? And the thing that the compensation is not as a matter of right, that only when you proved that there is the wrong committed under section 43, it does not mean that it automatically give you to the compensation, because it talking about the damages, unliquidated damages. In earlier classes also I have discussed that unliquidated means that are not predetermined, that the forum has to determine by seeing the facts and circumstances of the case on the evidences adduced by both the parties. Okay, uh, should I move further, guys?
Yes, sir.
Yeah, now the third clause, section 43, uh, that is about computer contamination. Okay, computer contamination. Section 43 clause C introduce or causes to be introduced. Introduce or causes to be introduced. Any computer contaminant or computer virus into any computer system or the computer network. Here, you know, uh, you see, there are two three issues that we should think about, though I have not gone through in this particular case about you, but someone may ask. The one is about this thing that where the adjudicating officer is saying that I held guilty both. There are two respondent in case under section 43b and section 66. So the question is like the earlier also raised in Vinod Kosi, that adjudicating officer is the civil forum, civil authority. How he can held the guilty? Because earlier also the same mistake has been committed. So this is one question, but it has not been cleared. Earlier also High Court got that opportunity, but High Court just denied that this is the something. The Madhivka is concerned, and she was not asking. So why you are concerned about that? And here also, but to the my understanding and my knowledge, that is not proper. That is not proper. But still, there are some confusion because the word penalty is written here. Then this type of the civil authority is making the guilty of section 60C without discussing that whether it has been done dishonestly or fraudulently, because that those are the very specific grounds provided there. So as a law student you should be very curious about it. And to my understanding, that is not proper, that the adjudicating officer is holding the respondent guilty for section 66. Okay, guys. Hello.
Yes, sir.
The second thing is, the second thing is also there. The second thing is that if you read, it's saying that if any person without permission of the owner or any other person download, copies, extract any data, computer database or information from such computer. From which computer? Such computer. Earlier also in last class I've said such computer means the computer to which this particular person does not have the permission. And this is, you can say this was in the uh, control or in charge of the bank official, you can say. Okay, definitely the data was belong to this particular person, but these data were from the or information from the computer to which the bank is the owner or bank has the in charge. And in that case, you know the section 43b gives right to approach only the person from whom computer the data has been theft out. Okay, so it's not talking about the affected party who are somehow related to that data. And so the proper person may be, because the concept of that what you say locus standi will come. How you will interpret it, how the broadly says without going into the detail of every technicality, you this type of the problem you will find at every moment. Because generally who is the adjudicating officer, सेक्रेटरी लेवल का जो बंदा होता है सेंटर लेवल पे वो होता, स्टेट लेवल पे वो होता है, सॉरी. Okay, so Rajesh Agrawal ji has decided in that way. But from my point also, that is also something on which the deliberation should occur, and some finding should be given, so that as a student we must clear and we must understand the real scope of this provision. Okay, so these are the two main point I have pointed out. just to make it clear that if this question is arising in your mind. Yes. Clause C is about computer contamination that introduce or causes to introduce. These two words shows, or these two words with the purpose that the legislature want to cover both the situation of the attempt, both the situation of the process by which one person is doing that activity, and the second, is about the completion of that. The second thing is that when one person actually he physically is doing, or maybe from the other person he is getting to done that person. Cause to be introduced, cause to be introduced means you are doing any act by which the computer virus or computer contamination entered into the computer of a person without his permission. And so cause to be introduced means you are doing any act by which the introduction was or the it was introduced. So which act it may be, you are through any process like the automated process you are doing, or with the help of some other physical person you are doing. So that thing it cover. So introduce word is not that he has introduced. When the introduced word is there, that means it has to be a complete process that has been done. And this type of the present use of the present sense actually want to with the effect of covering both the situation when he was in the process, or definitely covering whatever he already has done. Then causes to be introduced means actually he himself, the person himself is doing, or through any automated technology, or with the help of other person, or by saying other person, he actually introduce the computer virus or the computer contamination. Now the question is that what is computer virus and what is computer contamination? Can any of you would like to define, throw light that what do you understand by the word computer virus? किसी को कुछ आइडिया है? एनी आइडिया? प्रियंका, क्या होते हैं कंप्यूटर वायरस? यस, कोई तो बताओ भाई.
सर malware सॉफ्टवेयर होते हैं.
Malware software, that means computer virus are also the set of instruction, the software, but their function is destructive, you can say. यही कहना चाह रहे हो ना?
Yes sir.
Yes. दूसरा रोहित भी कुछ बता रहा था.
Sir, which affects the normal operation of the computer source.
Very good, very good. सबको पता है, पता नहीं आप लोग पार्टिसिपेट नहीं करते. Okay. See, there is one important thing that may be what is the understanding in the technical word. भाई टेक्निकल वर्ड में या टेक्निकल वर्ड मतलब दुनिया में आप इसको कैसे भी समझते हैं, या वहां पे उसका क्या मीनिंग हो रहा है. When we are talking about the law or the legal provision, there must be some clarity about it. Okay. And so it's advisable to define these words. Okay. Maybe in the technical sense you are understanding something else, but what is in the legal sense you have to comply with that. ये कई बार प्रॉब्लम आती है. काफी स्टूडेंट जो टेक्निकल बैकग्राउंड, उनको लगता हम तो ये पढ़ते थे, ये क्यों बता रहे हैं. And that confusion occurs. Earlier also I gave an example that when the when our national movement was there, and so how the freedom movement became the Indian national movement. Gandhi ji and other leaders, they want to make the participation of all the people. So वो लोगों के पास जाते थे, पूछते थे समस्या, किसी की कुछ सबके पास समस्या है. And so सबको आश्वासन दिया कि भाई हम जो ये कर रहे हैं, whatever we are doing, throwing out Britisher from India, We will provide such a system which give the equality, justice, all those things. And then, there were so many bad things in the Hindu religion, so government want to pass the a complete code related to Hindu, but unfortunately could not do. But it was passed in the four parts. One is Hindu, marriage and divorce, then Hindu succession, minority guardianship, ये चार एक्ट जो पढ़ते हैं. तो उस समय एक क्वेश्चन उठा कि बिकॉज देयर गवर्नमेंट वांट टू अप्लाई दिस लॉ टू फोर थ्री कम्युनिटी, हिंदू, बौद्ध, जैन एंड सिख, फोर कम्युनिटी पे. And so they have written that Hindu means both Jain and Sikh, just for applicability. And it was misunderstood, it was mistrued that here is the freedom of religions the government want to take, we are different from Hindu, they are merging us, but that was not there. So the purpose was that that restricted meaning is applicable to that statute only. So whatever our common parlance we discuss, yes, definitely we discuss, but whenever there is a question, we have go strictly through what is provided here. And so legislature has defined the computer contamination also, computer contaminant, and computer virus. Computer contaminant under the explanation that is attached to section 43. ओके, मैं यहाँ से अगर नहीं, मेरे पास है नहीं. ओके, and computer virus under the explanation 3. First I'm reading computer contaminant. Computer contaminant is also, same type of the things that having this tendency of destroying or modifying the information system or normal functioning of the computer. Computer contaminant mean any set of computer instruction. Any set of computer instruction or any set of computer instruction, you can also say the computer software. So any set of computer instruction that are designed by whatever name you call it, by whatever method you are created, but that is not important for the legal obligation. Any set of computer instruction, any means any, okay, small, large, in what format it is immaterial, that are designed, then two clauses: a, to modify, destroy, record, transmit data, program residing within a computer system or computer network. So suppose there is a set of instruction you introduce into the mobile of another person, and then this computer software is actually recording his what he is talking and then transmitting to you. It is computer contaminant. It is deleting the data, computer contaminant. It is destroying the data, computer contaminant. It is destroying, or modifying, then also computer contaminant. Clause B, by any means to usurp the normal operation of the computer system or computer network. Or maybe it's not modifying or destroying recording data or the program, etc., but it is making disruption, like Rohit has very well explained, in the normal functioning, then also it is computer contaminant. So computer contaminant, you can say in whatever we are understanding over the computer virus, also it is included in it. So it is a more general and common term. Now come to the computer virus, because both word has been used, and the purpose is that not to miss out any category that maybe in the future lawyer will say नहीं, ये तो आपने computer contaminant ही लिखा था, computer virus नहीं लिखा था, etc. And they even defined also the computer virus, but you will find that here also the computer virus more and less they have defined in the similar manner. Computer virus has been defined under explanation 3, that computer virus means any computer instruction, information, data, or program. So it may be here, it should not that it always be in the set of instruction. It may be in the form of data, it may be in the form of just the information. Okay, it may be data, that instruction, it may be data, it may be the program, तो फिर वही set of instruction हो गया. And the purpose that destroy, damage, degrade, adversely affect the performance of computer resource or attach itself to the another computer resource and operate when the program data instruction is executed or some other event take place in that computer the resource. So Sanjay and Rohit has very well explained that what is the meaning of the computer virus. Law is also taking the cognizance of that, that by whatever name you will call it, that sir it is not the instruction, it is a set of instruction, it is one instruction, or it is a program, or it is a data. If that program data have the capability of destroying disturbing the normal operation, etc., so that is the computer virus. But the computer contaminant also, that not only the clause B, because clause A and clause B in the explanation of one are separated by the conjunction or, not by and. And so maybe they are like the computer virus, and maybe they are not actually, neither they are disturbing the functioning of your mobile or the computer, nor they are destroying the data, they are transmitting. So China has put many this type of computer contaminant in the South African one building they have constructed for South Africa assembly, Africa assembly, or some other somewhere else also they have there are many reports, or maybe sometime rumors, that the Chinese phone have this type of computer contaminant that they record or transmit, or they there are some other thing that it is possible in the modern technology by set of instruction uh, you know can be introduced in a computer, and then whatever activity you are doing, all things will be recorded and transmitted to some other persons. So even recording, even transmitting, or the combination of both, everything is covered under the computer contamination. Okay, so this is about clause 3, computer contamination. But here also you have to prove the for the compensation, you have to show the damages also. Damages does not mean always monetary damages. Like in this earlier case, Amit Dilip Patwardhan, monetary damage he has not suffered, but he has suffered the privacy. But because that person was not with the clean hand, and so the adjudicating officer has not taken into the consideration. Otherwise, on the privacy issue also, agar ye independent mamla hota, so definitely adjudicating officer only on this breach, even if he has monetary loss has not been occurred, some compensation as an exemplary can be passed, because that can be passed. Okay, so with this today class is over, and if you have any question, any doubt, any query, you are welcome, please ask.
Sir, in this case, actually, basically, banks should